Hello and good afternoon. Thank you for joining us this Wednesday, October 16th, for today's webinar, A Beginner's Guide to the H-1B Lottery. We have a very packed presentation ahead of us, but as always, I do want to go over a few housekeeping items for today's attendees. Today's session will last for about 45 minutes, but I have a feeling we may go a little over that, so just keep an eye. We'll be keeping an eye out on time, but just an FYI there. That obviously includes question and answers from our attendees. So if you do have a question, please ask it and type it into the GoToWebinar box or that you should see on your screen. Additionally, you will receive today's recording and the accompanying slide deck in an email tomorrow afternoon. You'll be able to download both of those items. In that email, you will also receive continuing education credits from SHRM and HRCI. All right, so for those that are unfamiliar with Envoy, for nearly 20 years, Envoy has been on a mission to fix the confusing, frustrating, and inefficient immigration process. Envoy combines expert legal representation with innovative technology to deliver the only platform that makes it seamless for companies to hire, mobilize, and manage a global workforce. Envoy secures work authorization in over 150 countries, has grown 41% year over year, and works with over 1,000 customers. We are particularly proud of our NPS score, which is a testament to the employee experience that we provide. And joining us today from Envoy's affiliated law firm, Global Immigration Associates, is Christopher Preston, a managing attorney. Christopher's practice focuses on helping businesses and their employees maneuver the U.S. legal immigration and work authorization landscape, including employment-based non-immigrant visas, such as the H-1B, the L-1, O-1, and more. He also helps with employment-based immigration matters, such as the PERM process, I-140 petitions, and adjustment of status applications. Christopher works with clients in several industries, including data analytics and engineering. Christopher, thank you so much for joining us this afternoon.
Thanks, Eric. It's my pleasure to be here, and thanks everybody for joining.
Awesome. So, Chris, like I mentioned, we have a packed presentation, so just have couple more slides before I turn things over to you. Just want to provide our attendees with a quick overview of today's agenda. Again, based on we're going to start from the very top, looking at what the H-1B is, and then some of the labor, the LCA, and then some practice pointers, and then we'll end things with the question and answer, as I mentioned. And again, as a reminder, the content in this presentation is not intended as legal advice. For additional information or for additional questions, please consult with an Envoy-affiliated attorney or another qualified professional. Okay, Chris, so I'm going to start at the very top here. What is the H-1B?
Yeah, absolutely. Thanks, Eric. So the H-1B is going to be one of the most commonly recognized visa types in the employment-based U.S. immigration context. And one of the reasons why that is because it is, relatively speaking, the most open-ended employment-based non-immigrant visa. So let me unpack that a little bit. What do we mean by non-immigrant? Well, a non-immigrant is essentially someone who is not an immigrant, right? Although sometimes we use the term immigrant to refer to any individual who is from somewhere other than the United States. What we really mean by this is someone who is here temporarily. They're not here long-term, permanently. They're here as a guest worker. You may hear that term used. And that is the category that the H-1B falls under. And when I say open-ended, what I really mean is that in terms of the requirements to be eligible for an H-1B, an individual essentially only needs to be filling an employment role that requires a body of highly specialized knowledge that's evidenced by a specialized bachelor's degree. So to put that in layman's terms, it's basically for professional positions that require at least a bachelor's level education. And if you think about it, that really applies to a ton of jobs and a ton of people. Really the way, there are kind of two ways that we can restrict that qualification further. First of all, there's a numerical restriction, which is the subject of our conversation today, the H-1B cap lottery process that basically governs the number of people who can enter into H-1B status per year. The second is that when we talk about what is a quote-unquote specialty occupation, which is kind of the legalistic term for a job that requires a specialized bachelor's degree, we must keep in mind, and these are the bullet points here, that the individual must have a bachelor's degree or equivalent professional experience combined with education, or maybe even experience alone, provided that those things are equivalent to a bachelor's degree. And the degree must be in a specific field that relates to the position that they are carrying out. In addition, there are wage controls to the H-1B. Not all visas have this. As a matter of fact, only a few do have this. But the H-1B employee must be earning a wage that is commensurate with similarly employed professionals in the occupation in the geographical area. And those wage statistics are defined by the U.S. Department of Labor. And in addition, in the list that you see on the right, we have to ensure that the occupation that we're talking about is one that normally requires a specialized education in order to fill, such as accounting, engineering, the law, obviously. There's really only one degree you can get to be a lawyer. And same with medicine. Computer science is a huge one in terms of software development. So these are sort of prototypical occupations that do and will qualify for the H-1B visa. The next slide, we're talking about the amount of time that the H visa gives the visa holder in the United States. And this can be a little bit convoluted, but the way that I usually explain it is that a person gets 6 full years of H-1B status when their feet are planted on the ground in the United States. So you can think of it every day that they're physically in the U.S., that clock is ticking. If they're on an H-1B, that clock is ticking to a total of 6 years. Now, that being said, the U.S. government will not admit an H-1B into the United States for more than 3 years at a time. And for that reason, we can only petition USCIS for H-1B status for up to 3 years. So you can kind of think of it as 6 total years that are broken up into 3-year increments, or even smaller increments if the case requires that. That's the total stay. There are there's a couple major exceptions, or not exceptions per se, but exemptions from the 6-year, and that is if the individual has reached a certain progress point in the green card process. We won't dive into the weeds on that, as that really won't be super relevant to our conversation about H-1B cap. But just keep in mind that there is a release valve from that 6-year maximum, and there is no conflict. There is no legal conflict between being on an H-1B visa and pursuing the green card, because, as we mentioned here, the H-1B visa allows dual intent, which basically means the person can have the intent to stay temporarily while also having the intent to stay permanently, and accordingly pursue the green card and lawful permanent residence in the United States.
Hey, Chris, so as we move along to the next slide, you mentioned that there's a lottery for the H-1B, and there's a breakdown between the regular cap and master's cap. Can you explain this chart that we're seeing here and the breakdown specifically?
Yeah, absolutely. Yeah, so the regulations, the federal regulations for most employment-based non-immigrant visa types write in a numerical limitation. So, for example, one visa type will say, the U.S. government can only allot X 100,000 or X 10,000 of these visas per year. It just so happens that most of the visa types that companies use to sponsor their employees, they don't nearly have as much demand to reach those cap limits. So something that our HR professionals who work in this field may not know is that, for example, L1 visas or E3 visas or some of these other types of visas do have the same numerical limitation. It just so happens that we've never actually hit those numbers before. But in the H-1B context, the numbers are these. So we get 65,000 visas that are allotted per fiscal year. That is generally for H-1B recipients, but there's a set aside of 20,000 H-1B visas for beneficiaries who have earned a United States master's degree. So it has to be a master's degree or higher that was earned in the United States. It cannot be a foreign degree, and that is known as the master's cap. And those individuals get essentially 2 bites at the apple, and we'll talk about what order those bites come in and how that's changed in recent history. But if you have employees who have a U.S. master's degree, they do have a leg up in terms of their chances of being selected in this lottery. So, let me kind of discuss the lottery in general. Maybe I've gotten ahead of myself. So we have 85,000 visas that can be issued to individuals per fiscal year. That fiscal year, that's the federal government's fiscal year, which goes from October 1st to September 30th. And because there's 85,000, and every year since 2014, there's been more than 85,000 petitions for H-1B status. Normally in the last 5 years, we see numbers that range between 150 and 250,000 petitions for H-1B status per year. So it doesn't take a genius mathematician to start to do the odds on this. If we get 200,000 petitions to USCIS with only 85,000 spots, we're talking about a lottery system that has a less than 50% chance of success. And that is how the government governs that numerical limitation. And it really is a lottery in the strict sense of the word. And we'll talk about how, what lottery ticket, to use the metaphor, is being counted. But traditionally, and the way that the law is set right now, that ticket is the petition itself. And these petitions fill up thousands of FedEx trucks all over the United States and funnel into the USCIS. And USCIS will literally randomly select which of those petitions are going to be accepted for processing, and that's all before the case is determined to be approved or denied. So it really is a randomized lottery system in the strictest sense of the word. And as we'll discuss, there's really no, other than having a U.S. master's degree, there's no way to pad a person's likelihood of being selected. It's about as random as you can think of.
That's crazy. That's crazy to think about. You did mention, and as we move forward, a pretty big change that happened within the master's cap and regular cap, and that was the order of selection. Can you discuss this change that was implemented for the fiscal year 2020 H-1B cap lottery?
Yeah, absolutely. So last year, something really remarkable happened. And I apologize in advance. I certainly don't want my comments to be taken as politically bent or slanted, but I don't think that I'm surprising anyone when I say that the Trump administration's enforcement of immigration laws, regulations, and policies has been more strict. than in previous years. I think that's just the plain reality of the situation. But what happened was, surprisingly, the Department of Homeland Security actually made a change that was quite favorable to potential H-1B beneficiaries. It doesn't sound like much, but mathematically, it ended up having really an actual very, very positive benefit on the process, and that is the way that it used to be was that they would do the master's cap selection first. So as part of their lottery process, they would start with the master's U.S. master's cap candidates, select from them, and then once that was done, they would then move to the regular cap. But what happened was that they switched them, and what they claim, and we agree with this, is that this is actually a huge benefit for master's degree recipients because it gives them a better chance of being selected. And what we've seen is that it gives a master's candidate about a 16% increase in the likelihood of being selected. So really, the legislation behind all of this was intended to favor those individuals who have U.S. education and advanced education. We see that this policy change really brought that intention in line with reality and is furthering that intention much more effectively.
Awesome. And so we're getting near the end of this particular section, so we're going to kind of move forward with some numbers and timelines. Chris, when we're looking ahead at the calendar, what are some important dates, milestones that we should be aware of?
Absolutely. So as I said earlier, the fiscal year starts October 1st. In the employment-based non-immigrant visa world, it's a pretty standard policy that petitions can only be submitted 6 months, up to 6 months in advance of the effective date of the visa. So when we count back 6 months from October 1st, what do we get? We get April 1st. Or, if that falls on a weekend, really what we're talking about is the first business day in April that USCIS will begin to accept H-1B cap petitions. And again, H-1B cap petitions are for beneficiaries who have never been on an H-1B visa. So effectively, new H-1Bs are going to be subject to this lottery. For your folks who have been on H-1B visas before and still have time on their 6-year maximum, they're not, they don't have to go back into the cap, or they shouldn't. I guess it's going to depend on an individual case assessment. But once you've gone through the cap and you still have time left on your 6 years of H-1B time, you don't have to go back in. This is really for first timers. The big exemption from this is for employees of certain nonprofit or institutions of higher education, universities, et cetera, who the legislation makes clear are exempt from the numerical quota and therefore don't have to go through the H-1B cap petition process. So that's a big exemption there. And again, like I said, we're counting the visas that can be allotted in the fiscal year, which starts October 1st, which means that when we file for a cap petition in early April, that is a status that will take effect no sooner than October 1st later that year. So if we're thinking about 2020, we're going to be filing H-1B cap petitions in the first 5 business days of April. We'll discuss a little bit more later on about those 5 business days. But know that those will get approved over the spring, summer, and early fall, but they will not go into effect until October 1st of 2020.
So then, quick question there. So today's October 16th. So then is it the individuals who were selected in the lottery for fiscal year 2020, they were able to start working October 1st, a couple weeks ago?
That's right. And it gets kind of confusing. When we say fiscal year 2020, we effectively mean October 1, 2019 through September 30th of 2020. So you're correct. For those of you who had the great joy and pleasure of going through the H-1B cap petition process this previous spring, your folks who were approved should have gone into status earlier this month, unless their case is still pending, which, as crazy as it might seem, is the reality for a few, not for a few, for numerous folks out there. Certainly not the majority, but there are still cases out there that are still cooking with USCIS. But for the most part, you would have seen those people go into H-1B status October 1st of this year.
Gotcha. And as we wrap up this first section, you earlier highlighted just how quickly the cap fills up when it does open up. So as we take a look at this slide here, Chris, I think it just really highlights that. Are any of these numbers surprising to you, and just with regard to how fast it fills up compared to, as we look at fiscal year 2011, it took 301 days.
Yeah, so this is really a sea change in U.S. immigration, and we can kind of think about prior to 2014 and after 2014 as kind of the pivot point between two realities. The reality used to be that the cap opens the first business day of April and it doesn't close until we hit 85,000. And it used to take quite a while for that to happen. We used to be able to file cap cases in the middle of the year because the cap was still open. And there, effectively, there was no lottery because, the cap didn't shut down on us. But starting in 2014, that was when the real demand started to hit. And that's when we basically jumped over the 85,000 mark in the first 5 business days of April. And USCIS has implemented a lottery based on early April filings ever since. So it's important to understand that, the cap doesn't close until the maximum number of cases has been hit, but the government guarantees to us that it will stay open for at least the first 5 business days of April. So don't panic if you don't get your H-1B cap petition submitted on the very first business day of April, because you still have the 2nd, 3rd, 4th, and 5th business day of April to still get that lodged with USCIS and into the lottery. So when we start the petition early, what we're really saying is that you should be thinking right now about the candidates that you would like to enter into the process for next year. We will probably start assessing and processing these cases in early winter, as a matter of fact, this year. And probably start doing LCAs, which we'll talk about here in a moment, in early 2020. So the process starts early. Not to say that you can't reach out to us in March, letting us know. I will say that will be kind of up against the deadline for us. We'll be submitting hundreds of these. So if you do have cases that will come into us or your own employment counsel, whoever it might be, make sure to get it out in front of your attorney soon, sooner the better, so that we can get our ducks lined up well before the filing window opens.
Great. And Chris, that leads, you mentioned the LCA, and that leads perfectly into the next section. So I guess my question for you is, well, A, what is the LCA, and then B, why is it so important?
So every H-1B petition must have a labor condition application, certified by the U.S. Department of Labor. The labor condition application, first of all, everybody should understand this does not contain the employee's name or personal information. This is an employer filing for your position that the employee will fill, sort of as an abstract concept. So this is all about the position, the job title, the dates of employment, and the terms and conditions. Most importantly, the salary that will be paid and the location of the job that will explain the employee's position in the company. And so this is where we basically tell the government that the employee will be on the H-1B for this amount of time, making this amount of money, which, as I said, there are wage controls here, and this is kind of where that all plays out. Establishing that they are meeting the required wage by the government and that they will be working in a specific geographical area. And that's going to ride along with every H-1B petition that an employer files. For the next slide, we're thinking about, the H-1B cap So it's important to understand that the DOL is going to take, usually takes 7 days to certify an LCA. Sometimes when they really get bogged down and they get system outages, it can take even longer. So like I said, we will be filing these with the Department of Labor, if not late this year, then definitely early next. And once we start to get into mid-March, that's when we really start to make you aware that this may not be able to be filed if the DOL can't get back to us on this LCA in time before March 31st, which is kind of the send-off day when all the petitions do overnight delivery to arrive at USCIS on April 1st, if that lands on a weekday. And understand too that there's a little bit of a registration process. So if you don't think your company is registered in the LCA system, make sure to be on top of that right now. Reach out to your attorney if you need assistance with that, because that should be happening basically now.
Gotcha. So Chris, as we move along in this particular section on the LCA, can you discuss some of the details that employers need to provide?
Yeah, absolutely. So there's a lot of attestation here, which basically means you're checking yes to, some things about if you're having a current labor dispute, you agree to give notice to the employee. It's also important to understand that you're giving notice. You'll be required to give notice to your workforce that an LCA has and will be filed for that particular case. And this is known as a notice of filing. It's important to understand that. We'll dive into that a little bit as well. But specifically, wages are going to be a huge thing because, again, the LCA is the document on which we confirm that the employee is making the required wage for the H-1B. Here you'll see that we need to attest that the employee is making what I call, generally is called the required wage. The required wage actually breaks down into the higher of two things: the actual wage, which means the wages that you pay to other employees who are employed similarly in the same position, or the prevailing wage. You'll hear prevailing wage as a catchword that's used a lot. And essentially the prevailing wage is what the Department of Labor has listed as the prevailing wage. I mean, statistically, it is the wage that on average similarly employed individuals are making in that occupation and in the geographical area. Also, you must attest that the working conditions for H-1B holders are going to be the same as to those of similar employees. Obviously, for most companies, that's not going to be a problem. These folks are going to be sitting right next to the rest of the team, working with the same technology in the same location. So usually that's not a huge concern. Again, if you have a labor dispute, work stoppage, strike, or lockout, it's something that may hold up an LCA filing, but that's pretty rare. If you do have a situation like that, you think you can't file an LCA because you can't attest that one of those things is not going on, I would strongly recommend reaching out to an attorney about that. But like I said, that's not going to be the case in most situations. LCAs are public. So when you file an LCA, it's actually visible with a few exceptions. It's visible to anybody who wants to go on the Department of Labor's website and look up LCAs. They can narrow them by company, by position. They will redact things like your FEIN number, but they will see that you filed an LCA for a particular position and are paying a particular wage for that position. Also, like I said, there is a notice of filing component by which you need to basically notify all of your employees who are working at that particular work site where this H-1B will be working, that an LCA will be filed. That's just a compliance requirement by law that you do that on the day of or before you file the LCA. And that posting has to be up for a week, essentially, before as part of the LCA filing process. 10 days. I'm sorry, 10 days, not a week.
Gotcha. So, Chris, after the LCA, what is the next step or next set of steps?
Yeah, so we are essentially, once we have the LCA file, we'll be preparing the rest of the petition. And what that petition is going to consist of is information about the company, promotional material, informational material, marketing material, and then most importantly, a description of the position. That's going to be on a statement signed by signatory of the company, whether it's CEO or HR manager, whomever it might be, along with information about the terms of employment, the duration of the employment, where the employee will work, what they'll be doing, the minimum qualifications for the job, and a description and evidence regarding the employee's actual education and experience credentials. And when we talk about wage controls and we talk about the prevailing wage, we also have to show that the company has the financial ability to pay the prevailing wage. I mean, if you're hiring an H-1B and telling the government that they're going to make $130,000 a year, but it just so happens that this is a very small company and their annual revenue is only $80,000 a year, that's going to be something that USCIS will push back on and require further evidence. So for bigger companies, that shouldn't be a problem, but the evidence that we're providing to prove down this particular issue are tax returns, annual report, in addition to make it clear to USCIS that the company is up and operating and in existence, and this is not fraudulent at all. We might include as well, copies of business registration, business plans, client lists, again, marketing materials, annual report showing that the company is alive and well. All of that evidence is going to go into the petition. And of course, the employee's education credentials are very important. We mentioned that the H-1B is about individuals who have a degree in a specialized field. If they have a U.S. degree, that's going to be very easy to show. Just a copy of the diploma, a copy of transcripts. If they have a foreign degree, we'll be providing the same thing. But in addition, we will have to rely on the expertise of an education evaluation company that will give us a report that states that the individual's credentials are equivalent to a U.S. bachelor's or higher degree in the field that we're looking for. So it's not enough to just show them copies of a foreign degree. We must also have evidence that their education is equivalent to what they would have gotten if they pursued a U.S. degree. So here's some logistical information about what status the person might be in. If you have individuals who are in the United States currently and they want to change to H-1B status, I think that's the majority of cases. If you have, for example, F1 student visa holders, we can file to change the individual status effective October 1st of the same year. But as part of that, we have to show that the employee is here in the country legally. So talking about the evidence that rides along with a petition, if we're doing a change of status, we must have all the evidence regarding the individual's immediate status in the United States. The example being if a person's on an F1 visa, we're looking for a copy of the visa itself, their most recent I-94 admission record, their I-20s, which are the forms that their school gives them for F1 status. And if they have OPT work authorization, we're providing a copy of the card as well. If, on the other hand, you're filing to have the person activate their status from outside the United States, the petition really does not require all that information. In that instance, once the petition is approved and once we're nearing October 1st, the person can apply for an H-1B visa at the U.S. consulate or embassy in their home country, get the visa, and then enter the United States, and then they're effectively in H-1B status, as opposed to having it changed by USCIS.
A lot of helpful information in this section. Thank you so much, Chris. Moving along, you mentioned that part of the petition is the job descriptions or a job description. So first question for you is, why is the job description? I'm getting tripped up on my words over here. But why is the job description so important?
Absolutely, the job description is important because again, we have to persuade USCIS that the person is filling what's known as a specialty occupation. And of course, the question that comes after that is, well, what occupation are they filling? And to show that, we have to provide USCIS a detailed explanation of what the employee is going to be doing, and therefore justify their classification in that particular occupation. So if we're saying that an employee is in the occupation of software developers, which we have to do as part of the LCA, we then have to sort of put our money where our mouth is and tell USCIS what the employee is doing so that USCIS agrees that they are in fact a software developer and part of a specialty occupation. So a lot of companies have canned job descriptions. I can tell you from experience that more than 90% of the time, these are pretty vague, and for obvious reasons, right? You don't want to pigeonhole a job so much that you might scare away people who don't want to apply for it, or you want to leave a bit of wiggle room for other duties that the individual might take part in. But in the H-1B context, in immigration context in general, we want to be as specific and defined as we can possibly be. We want to be emphasizing advanced concepts and knowledge that the person must have, and make it very clear what the individual is doing. A good example of this in the next slide is you might see on a canned job description something that says, develop high quality software for our business. I can tell you right now, USCIS is going to hate that. They don't know what that means. They don't know they barely know what software is. No offense to any USCIS employees who might be listening to this right now. But instead of that, what we might say, and what we would encourage you to say, is utilizing technologies including Java, Ruby, and Python. In other words, explaining the actual programming languages that the person will be using, and then defining what, on a day-to-day and technical basis, the person is doing, so that we're not leaving any room for, confusion. Another example might be communicate with other teams about business requirements. Again, I don't know what the heck that means. But what I do know is that if the person is collaborating with internal departments, including HR, fulfillment, and accounting, to identify software needs for shipping tracking platform, that's pretty dang specific. And I don't think USCIS should have any beef about that. And then final example, analyze business metrics. Pretty vague, pretty unclear. And then right here we have a more defined, more specific example. So, you may be sending us a job description you have on file. That's great. We definitely appreciate that, and we'll be referencing it. But don't be surprised if we follow up and ask for a little bit more detail about what some of these vague duties really mean, and getting the manager's input if necessary to kind of build those out a little bit further.
Gotcha. And so, Chris, in our next section here, requests for evidence. So, what are requests for evidence, or RFEs? I guess we'll kind of just start there. We do have some updated stats to share, but I know this is a term that has been used a lot. So what can you tell us about RFEs?
Yeah, absolutely. So in the H-1B CAP context, we first filed a petition, and the first step is whether or not it gets selected in the lottery. And this is really important to understand. USCIS does not care what the petition says at that point. The petition is effectively a number on a piece of paper. They haven't even looked through the job description. They don't know who you are, who the employee is, or what they're doing. They're just picking the actual paper out of a hat. Provided that the petition is in fact accepted, which is great news, and we'll be celebrating with you when that happens, then it moves on to actual adjudication, in which USCIS, rifles through all of the documents in the petition and decides whether or not to approve the case. And once they've done that, there are only a few options there's only a few outcomes, immediate outcomes for the petition. Number one is approval. And that's the champagne option, right? It's going to be effective October 1st, and really we just have to wait until that date comes before the person is in H-1B status. They can also deny the petition outright, which is very rare. Something very egregious had to have been missing from the petition for them to do that. But if they don't decide to approve it, what they're most likely going to do is issue a request for evidence. And that's exactly what it sounds like. It's just a document that says from USCIS, we haven't approved your petition because of these reasons. Please send us this information. You as the employer will get a copy of that. If you're represented by counsel, they will get a copy of that as well. We'll usually have a 90-day period in which to respond to that. Sometimes they shorten the deadline a little bit. Usually it's 3 months by the time we have to respond to USCIS with that information. Here's a numerical chart that just shows, how relatively difficult immigration has gotten, especially in the H-1B context. The USCIS is really hitting us on all cylinders with RFEs, even for very strong cases. Sometimes you might see these RFEs and go, wow, either we already provided this, or I can't believe that we have 50,000 employees, we generate $15 billion a year, and USCIS is asking us for evidence of ability to pay the proper wage. What's that about? Well, they like to do it for nearly, any case they want to do it for, and you can see it from these stats that they're doing it for many more cases. And so the percentage of H-1Bs that are getting an RFE is nearing 50%. I think it's up over 40% of all cases right now. So it's just something to be aware of. In the next chart, you'll see cases approved with an RFE. So this is approval ratings, and I don't want to be Chicken Little. I mean, certainly the vast majority of cases are still H-1B cases getting approved. I can speak on behalf of GIA and say that we are much higher than what these suggest. We're not getting 65% of cases approved. We're probably up beyond 85 or 90%. But the rates have gone down. And this is a USCIS that is not as friendly to the H-1B visa as it used to be. That being said, it's usually more of a case of, more time, energy into RFE responses. But at the end of the day, that case is most likely going to be approved, provided that we get the right evidence submitted to USCIS. So don't think that you can't put your feet into this world because the sky is going to fall. That's definitely not the case. It just so happens that it takes a little bit more energy and resources these days to get these approved.
Yep. Chris, I just want to add a quick note regarding these two slides. So for all of our attendees that receive the slide deck tomorrow, that link that you see at the bottom, that comes directly from USCIS. It was actually released on October 9th, so these are the most up-to-date stats, and it covers the entirety of fiscal year 2019. That link will take you to a 25-page PDF that covers RFE rates for non-immigrant visas. So we have there's H-1B, L-1A, L-1B, and more. So if you're curious at RFE rates, numbers, and anything like that, please click that link to dive deeper. So Chris, what do these numbers mean for employers? You kind of touched on it just previously, but what else what other comments are you able to provide?
Yeah, so like I said, the RFE naturally is going to create a little bit more time for the case to be approved. It's going to create a little bit more cost if you have legal assistance, an attorney who's helping out with these H-1B petitions, which I do recommend. As we say here, USCIS typically approves a case when the RFE has been responded to, or denies a case. It is possible, but sometimes it doesn't happen. Sometimes we, respond to an RFE. It can take longer. As I said earlier in this discussion, we have cases that were filed in the CAP last April, and they're still pending. They might be pending yet for another 2 months. So it's not completely out of the question that USCIS does take several months to respond to finally adjudicate these petitions once the RFE has been responded to. So just be aware that there are cases in which the processing timelines get a little bit beyond expected. Here are the greatest hits in terms of RFE reasons. Is the job does the job belong to a specialty occupation? This is absolute far and away number one. It's part of probably 80 or 90% of every H-1B RFE that's issued. You file a case for, let's say, a computer systems analyst. USCIS will follow up and ask you for evidence that the job and occupation generally does require a specialized degree in a specialized field. That's a huge reason for a lot of RFEs. Employer-employee relationship has become a very, very very hot topic, particularly if you're sending employees outside of company premises to work on the premises of third parties. So if you're, sending a computer engineer to go tinker with the software of a client, USCIS is going to request evidence that you are that employee's employer and not the client. So that's a very popular one. Beneficiary qualifications. Does the employee have the education that is in line with the occupation? For example, if a software developer has a degree in electronics engineering, does that really qualify them for the software developer role? We think so, but sometimes USCIS doesn't. And maintenance of status. So for change of status petitions where you're trying to change the employee from F1 to H1B is a great example. And let's say, the person has a gap in their documents that suggests that they might not be maintaining their F1 status. USCIS will issue an RFE to clear that up.
So you kind of touched on these two slides here, so won't keep them up for too long. Let our attendees review them. Again, every attendee will receive the slide deck here, and then the other two common RFEs that Chris just discussed. So we are at 1:47 p.m. and I do want to just be mindful of everyone's time. Chris, I think we have we can maybe extend it for a couple more minutes if that's okay with you.
Yeah, completely.
Awesome. So that's going to lead us into an interesting topic that we do have, I believe, 2 slides on. Electronic registration. Throughout the presentation, we have been getting a couple of questions regarding electronic registration. So, Chris, what is electronic registration, and why is it top of mind for so many attendees joining us today?
Yeah. So, if you recall, I said, what is the ticket that you basically, or what is the, how do you enter the lottery? Well, right now it's a full-blown petition. It's forms, it's LCA, it's signed employer letter, it's copies of it, the employee's documents, et cetera, et cetera. Some of these are hundreds of pages long. What USCIS has proposed is that instead of that, we basically just send in a piece of paper with a number on it and some very basic information, and they use that to draw out of a hat. And if you've been drawn out of the hat, then they follow up with us. They follow up with you and say, okay, you've been selected, now submit your petition. It does make sense. I mean, a lot of practitioners in this field like the idea, but what is causing confusion, stress, and consternation is that they haven't been very quick to the punch when it comes to implementing this, or at least announcing that it will be implemented and how it will be implemented. They are still standing by their statement that this will go into effect for fiscal year 2021. In other words, the CAP process for next spring. But it has not been finalized, and it's October. And like I said, we've already started to sort of prepare these and to assess these. So there is a lot of speculation out there that it will be delayed again, but no confirmation yet. So there's still a lot of uncertainty about this, but we know generally what it's going to look like, but not exactly how it's going to work. So there's kind of a big question mark we still have to put on this at the moment. Yeah, and like I said, here's a statement by USCIS that USCIS intends to implement the registration process for fiscal year 2021. So that will be April of 2020.
And obviously, when and if this announcement comes through, Chris, we will obviously, put up a blog regarding some more information. So please keep an eye out for that. So that's going to bring us to the end of the main presentation. we've gotten quite a few questions in, so we'll take some time to answer those. If you do have a general question about the H-1B lottery, please feel free to ask it. Again, please try to keep these questions to a high level. We can't get into case-specific type questions. I'm just going to fly through some of these final slides here. They're the final housekeeping slides. Click this link to sign up for some future webinars. Sign up for our mailing list to receive webinar invites. And then here are the SHRM and HRCI continuing education credits, which you will also receive tomorrow afternoon in a follow-up email. So, Chris, kind of starting back at the top regarding the H-1B lottery, you mentioned it's completely random, correct? So how does USCIS know who to pick for the lottery?
Well, again, it's, they start with the regular cap. They run the cap, and they basically, you can think of it as numbers 1 through 200,000, and every case has an assigned number. I believe they use a computer system to randomly generate the list of selected cases, and those cases are by issued a receipt notice that the employer receives, and that receipt notice tells the employer that the case has been accepted. They then do the master's cap, which, as I said, is a benefit for master's recipients, and issue receipt notices likewise. Those usually occur sometime between April and July, and it's really fluid. Sometimes if we go into August, we still don't know what the result is. We haven't received a receipt notice, but once we've hit, kind of middle to end of July, we haven't received a receipt notice on the case. We know that the case has most likely not been selected. And then we know for sure later than that when they send a rejection notice along with the full petition back to the employer. And it contains everything that was sent. It contains the checks, the signatures, and everything. And that's your official notification that it wasn't accepted. So again, it's fully randomized, and it really has nothing to do with the merits of the case or what's actually sitting inside that petition.
Gotcha. Another question regarding the LCAs. You mentioned that they are publicly available. Do you have a particular website you're able to find these on? Is it the iCert website?
Yeah, so I can't tell you the exact website off the top of my head, but if you Google LCA registry, it will send you to the Department of Labor's Employment and Training Administration, known as DOLETA. There's a system by which you can search for LCA.
Yeah.
But yeah, they are out there. Yep.
Okay, cool. Yeah, no, exactly. Exactly like Chris said, if you Google LCA registry and click the first link that pops up, it'll take you to a list of LCAs that you can search for or search. Let's see here as we move along for some other questions. Chris, how many times can an employee apply for an H-1B if they are not selected from previous lotteries?
It's a great question. The answer is as many times as they want, or as many times as their employer wants, effectively. And the unfortunate reality is that if you aren't selected, let's say in 2018, you do not get any kind of priority or leg up in the following year. So your chances are not changed, even though you've tried and failed in past years. But there is no limit to the amount of time that an employee can be sponsored for the H-1B cap. I mean, you just keep going until you get selected, effectively.
Gotcha. Let's see here. Can the number for the master's cap, that's 20,000, correct?
Yes.
And does the master's cap typically fill up?
Yep, it has every year starting in 2014. So that's just the reality these days. I mean, there are U.S. master's recipients that have been they've not been successful in the cap for successive years. So it is a reality.
Gotcha. Another question. I got an interesting question here. So premium processing. Does premium processing guarantee or offer a higher chance of being selected in the lottery?
It's a great question, and it's something that it's kind of a rumor or mystery that just will never go away, even in the legal community, even among immigration attorneys. So there are some attorneys out there that continue to believe that USCIS is so money hungry that if you file an H-1B cap petition with premium processing, that it might have an increased chance of getting the case approved. I don't believe that. I think that it's just a rumor. I think it's just this misconception. What we've seen is that premium processing does not increase the likelihood of a case getting approved. What it does ensure is that if a case, I'm sorry, I said approved, I meant accepted. If a case is accepted with premium processing, what it does ensure is that we will know the result of the adjudication of the petition sooner than we otherwise would under normal processing. And USCIS will tell us when the premium processing clock starts. So let me explain this. So premium processing means for an additional fee, USCIS will agree to adjudicate the petition in 15 days or less. When those 15 days start, USCIS announces on an annual basis. So they will tell us this year, premium processing will begin effective May 15th, which basically means we will know the outcome of that petition if it's been accepted in the lottery by May 30th, which in some cases where we don't know, the person wants to know the results sooner rather than later, they've got something going on in their life, they have to make a decision, it's advisable in those situations. But in any event, the H-1B is not going to be effective until October 1st. So it has really kind of limited utility. It's really mostly for those cases where we want to know about the H-1B result as soon as possible. We cannot afford to wait over the months in the spring, summer, and fall to know what the outcome is.
Gotcha. Let's see here. I think this will be the final question since we are approaching the 2 o'clock Central Time. Chris, what type of nonprofits are exempt from the H-1B cap?
Yeah, it's a great question. Effectively, you're looking at post-secondary educational institutions, nonprofits, research organizations, those kinds of things. What I would say is that if you have a question about, here's what our organization is, here's what they do, I would really reach out to an attorney to get an assessment of whether, your employees will be cap exempt, because this is really a high touch legal area. But if you are a nonprofit, if you're an educational institution, I would definitely reach out to see if somebody can answer that question for you on an individualized basis, because I don't want to make too many comments that'll maybe turn people on or off to whether or not that applies to them.
For sure. Thank you for answering that one, and thank you for answering all of these questions. And final thank you so much for this presentation today, Chris.
Thanks, Eric. Thanks everybody who's joined. Thanks for everybody who asked a question, and hope you all have a wonderful week.
Awesome. Thank you so much again, Chris, and thank you for everyone for joining us today. As a final reminder, the recording, slide deck, and the continuing education credits will be sent out tomorrow afternoon. Have a great rest of your Wednesday afternoon.